So I'll just for a couple minutes. Hello, everyone, and welcome to the Duke Environmental Law and Policy Forum's 26th Annual Symposium, which this year will be on water law and policy. We're really excited to have you all. For those of you that don't know, the Duke Environmental Law and Policy Forum is a law journal. We put out a fall issue, we put on the symposium, and then we put out a spring issue that's based on publications from some of the speakers that you'll see here today. We were really excited to choose water law as our topic for this year's symposium because of how obviously necessary water is to our day-to-day lives, how tangible it really is. I think in this past year, that's really been brought into the forefront of a lot of people's minds, from things like Flint, Michigan, where we've seen how terrifying it is when people don't have access to clean water, to the droughts on the West Coast, which will be talked about later today, and we're seeing people struggling with agriculture and having enough water for human consumption. Water truly is necessary for all of our human communities to function. So we're really excited to have brought together a bunch of great panelists to talk about a lot of different aspects of water law and policy. And to get things kicked off, we're going to have a panel on coal ash, which has, of course, been a big issue for North Carolina ever since the Duke Energy spill in February of 2014. So with that, I'll let Michelle introduce the panel.
Hello and welcome to the symposium. My name is Michelle Nowlin. I teach a class in food and agriculture law here, but my primary role is as the supervising attorney for the Environmental Law and Policy Clinic. So our first panel today is going to focus on coal ash, not just in North Carolina, but also what's been happening nationally. I think that it's maybe helpful to pull back a little bit and think about what it is that we're addressing. What is coal ash coming from? How is it produced? Why is it a concern, a topic of concern? And when we often think of electric utilities or power plants, we think about air pollution or maybe greenhouse gas pollution. And I'm glad that this panel is leading off, because power plants are also a significant source of water pollution, not just in North Carolina, but around the country. They are polluters of our streams, our rivers, our lakes, and as we're increasingly coming to understand, even our groundwater. EPA has estimated that coal-fired power plants are responsible for more than 1/2 of all toxic pollutants that are discharged to surface waters from industrial sources, and they are sources of mercury, lead, selenium, thorium, carbon dioxide, particulate matter, and a number of other different pollutants. Now, some of this comes from atmospheric deposition. When coal is combusted, it emits from the stack. It then is deposited back down at some point on the earth. But a lot of it also comes from direct discharges of coal ash, wastewater, into surface waters, and also from leaching into groundwater. Part of that is responsible, or the outgrowth of the way in which coal ash is regulated, or to some extent, perhaps not regulated nearly as closely as it ought to be. Citizens and scientists have long expressed concern about this, but it has taken catastrophic events, such as the one Ethan referred to here in North Carolina with the Duke Energy coal ash spill in the Dan River, but predating that, the TVA power plant in Tennessee about 7 years ago. That is what it took to alert the general public and to elicit corrective action from our regulators. And that, unfortunately, is all too frequent in the area of environmental law. Some catastrophe precedes the understanding for the need for action and regulation. So our speakers today will address this national problem. Our own Professor Ryke will start off by discussing the national scope of the problem and providing an overview of the scientific research that documents the impacts of the pollutants that are present in coal ash. Mr. Frank Holleman, who is an attorney with the Southern Environmental Law Center in Chapel Hill and leads that organization's coal ash litigation, will provide an overview of his work and an update on what's currently underway. Ms. Lana Pettus, a trial attorney with the Environmental Crimes Section of the U.S. Department of Justice, will then address the scope of the government's prosecution of Duke Energy and identify the factors they evaluate in weighing charges and fashioning plea agreements. And then we will make sure to have plenty of time for questions from the audience and engagement with the speakers. So I'm going to just briefly provide a more formal introduction of each of our speakers. Ms. Lana Pettus is a senior trial attorney in the Environmental Crimes Section of the U.S. Department of Justice. She has worked in this agency since 2004 when she joined the section through the Attorney General's Honors Program. And a little footnote there, she has information for those of you who may be interested in working with the Department of Justice, either as an intern or entering through the Honors Program as she did. So make sure to talk to her at some point during the day if you are interested in learning more about that opportunity. Ms. Pettus has handled cases involving the Clean Air Act, the Resource Conservation and Recovery Act, the Act to Prevent Pollution from Ships, and the Lacey Act, in addition to the Clean Water Act. She's also been an instructor for other prosecutors at DOJ-sponsored training programs and for agents and prosecutors from Eastern Europe and South and Central America through the State Department and EPA-sponsored programs. So we're very happy that she can join us today and share her expertise with us. Ryke Longest teaches water resources law here at Duke, and he also directs the Environmental Law and Policy Clinic, which teaches students how to represent nonprofit environmental organizations as part of a larger public interest law firm here at the university. Before he became a professor, he was a special deputy attorney general working for the North Carolina Department of Justice. During his career at that agency, he represented state agencies charged with protecting North Carolina's environment. Ryke's practice has included client counseling, trial representation, and appellate work at all levels, and his research interests include water resources, water quality, air quality, fisheries, oil and gas law, and administrative procedure and environmental justice. So thank you, Ryke, for joining us. Finally, Frank Holleman is a senior attorney with the Southern Environmental Law Center in Chapel Hill, North Carolina, and he coordinates SCLC's coal ash work across the southeastern United States. Prior to joining SCLC, he practiced law with an emphasis on litigation at the law firm of White, Burgess, Freeman, and Parham in Greenville, South Carolina. Prior to that, he served as the United States Deputy Secretary of Education, as Chief of Staff to the U.S. Education Secretary Richard Riley, and as a Deputy Assistant Attorney General in the Civil Division of the U.S. Department of Justice. Mr. Holleman served as a law clerk for U.S. Supreme Court Justice Harry Blackmun and Judge Harrison Winter of the U.S. Court of Appeals for the Fourth Circuit. He is a graduate of Furman University, Harvard Law School, and the London School of Economics and Political Science. And in 2010, he received the Environmental Awareness Award from the state of South Carolina. So thank you, Mr. Holleman, for joining us. And we will now start off with Professor Longest. Do you know which one?
It'll be the one in the center. That one.
Okay.
That's it. Got it. Great. Thank you. Good morning. Before I forget, there are a couple of research articles, scientific research articles that I'm going to refer to here. I didn't make copies for everyone because I didn't know how many people were going to be interested in them, but I do have 10 copies. I'm going to put these up at the front. You'll also have on the slides references to these articles so that you can pull them up yourselves. And they're from professors on the faculty here at Duke University and the Nicholas School of the Environment. So I'm going to put these right up front in case I forget. Thanks for the introduction, Michelle, and thanks for the opportunity to be here. I see many current and former students and colleagues in the audience, and it's great to have such a good gathering to talk about what is definitely one of my favorite subjects. Water policy generally, and also the largest industrial waste stream that we have in the United States, about which, until recently, many people, including myself, were blissfully, I won't say unaware, but blissfully, shall we say, naive about how this problem was being treated in our environmental law and policy system. So we're going to talk a little bit about the scope of the problem. What is it that we're looking at? So this is some electron microscopy of what a coal ash, fly ash particle looks like. This is down, the picture on the left is down to the micrometer level. This is down to the nanometer level. This is only one component that is composed of what we call coal ash, or what is often referred to as coal combustion residuals. You'll see this Ccr, or coal combustion residuals, a lot. I think coal ash is a better way to describe it. Coal combustion residuals is probably a little more technically accurate because it's a bigger group of materials. But there are four components that are going into this category we call Ccr, and it's just easier to say coal ash, and that's really reflective of what this material is. The four main components are fly ash, which is what these particular pictures are of fly ash. This one on this side is a picture at the micrometer level showing you what appears to be sort of a glassy sphere. And then you'll see the little fuzzy sort of hairy aspect to it. This is when you get to the nanometer level and you look very up close to the surface of this, there's surface coating on these little glass particles. Now, fly ash is created as coal is combusted and materials go up into the flue, and they actually, the mineral portion, silica, actually turns into little glass beads and goes up and becomes part of the emission, if you will, stream going up through the air of the coal-fired plant. It's filtered out through many of the emissions controls. You know, we have under the Clean Air Act, and I certainly participated when I was at North Carolina Department of Justice in developing some of the rules and procedures and permit requirements that were applicable to these plants to collect this material. Because when you have particulate matter coming up through the stack, it can have health consequences from a clean air perspective. We can breathe in these particles. They're damaging to our circulatory systems. Some of them are so small they can pass the blood-brain barrier. And so controlling this particulate emission was a key strategy of Clean Air Act enforcement. Well, as we've captured that material and done a better job of capturing those materials, we've created what was an air quality problem. We have turned into a solid waste problem. And that solid waste problem is only increased in magnitude over the years as we have captured a new set of materials that were also going out the flue, and those are the sulfates. So another key component, so about 60%, generally speaking, and these are rough numbers, about 60% of this coal ash are these fly ash particles. And they are silica, and then this surface coating can have all kinds of other forms of impurities. Other items that are on it can be attached to that surface coating. The next level that we're going to talk a little bit about is the FGD waste, or flue gas desulfurization. So as we've taken efforts to pull sulfur out of the exhaust stream, we've created another waste product referred to as FGD. That's about 24% of the volume of this material. Then there's heavier particles that fall to the bottom of the combustion chambers. This is referred to as bottom ash, and it's too large. It doesn't go through the air. It doesn't get airborne like the fly ash does. It's escaping up. It's residue that's left at the bottom of it. And then there's a thing called boiler slag, which is a very small portion, about 4% of this total. Boiler slag is material that's left at the very bottom that's forming like a another sort of glassy bead appearance. So these two, if you combine them together, boiler slag and bottom ash, only about 15%. But all of these have in them many of the basic elements of coal that aren't combusted. As we know, coal, organic compound, but it contains within it trace elements from all across the periodic table. And so in this material, we're going to see mercury, cadmium, arsenic, and many other elements that become significant problems in the aquatic environment. So this, just to give you a scope of this problem, we're talking 110 million tons per year. we're talking, if you were to make a train with boxcars, it would go from Washington, D.C. to probably the South Pacific. I've heard people say as far as Australia. I don't think there's rail lines yet from San Francisco to Australia, but in any event, we're talking a very, very large volume of waste material. And this is also a national problem. So this map is intended to show where the coal ash ponds are distributed around the United States. And the ash ponds are, you'll see a lot of them here in the southeast, but we're not alone. There are other parts of the country that do have these coal ash ponds. And the big issues associated with them, with the coal ash ponds, are as they impact water quality. We're going to talk about two primary issues related to that. One is the spill. So these ponds are unlined in many cases, and in some cases structurally unsound. They are a result of what I would call an iterative solution, almost as if you were to think about if you've ever had a junk room in your house, or maybe a junk drawer in your kitchen. There's a tendency over time, especially if you're sharing space with more than one person, to accumulate odds and ends in that junk drawer. Maybe that's where all the soy sauce and yellow mustard from the Chinese food ends up. It all ends up in this junk drawer, and eventually it kind of just fills up, and you're to the point where you don't have anywhere else to put it. Well, then what do? Well, you find another junk drawer, or dump that stuff in a box and put that over to the corner. That's kind of the way coal ash has been for us, that there was a time when coal ash was being discharged directly to rivers, and people realized, well, this is poisonous material, so let's instead put it in these ponds, let it settle out, then we'll discharge the clean water from the top of that. Over time, these ponds have just gotten more and more full, and people have procrastinated on dealing with the issue. And that procrastination led to tragic consequences in Kingston, Tennessee, as Michelle alluded to. So this is New York Times cover story, December of 2008, looking at the Clinch River in Tennessee, where a coal ash dike failed catastrophically and caused tremendous devastation to people's lives, to the community, and to the aquatic ecosystem. The estimate on the sludge volume there was 5.4 million cubic yards. So that's enough to flood 3,000 acres 1 feet deep. 3,000 acres 1 feet deep full of sludge that went into this river. The initial TVA initially said that the whole volume, that is the entire volume of this pond, was only 2.6 million cubic yards. So they didn't even know how much ash they were holding on to. So this is one of the fundamental problems. So they started looking, immediately started looking in the river to what's in the river after all this. And we started finding good, fun stuff like lead and thallium. But one of the chemicals that was of most concern, and this is Dr. Laura Rule and Dr. Avner Vengosh here of Nicholas School of the Environment, did a long-term study looking at the movement, fate, and transport of contaminants after this spill, and added a great deal of understanding to the scientific community about how these pollutants move through the system, what is mobilizing them, and what impacts they have. And so he's looking, this particular table is from their 2010 study. I got a copy of it up front if you want to look at the whole study, looking at arsenic. And this is arsenic from the Kingston, Tennessee spill. This left column is showing the discharge in the Emory River. So this is volume of discharge on this axis. And on this axis, it's the concentration in micrograms per liter of arsenic in the water. And then these, the red lines here are showing, the black lines are showing, the red lines are showing the discharge, the black lines are showing the arsenic concentrations at various sample points. One of the take-homes from this is that arsenic spikes followed not just the spill, but also some of the dredging activities. So it's not only a problem when we spill the material, but actually when we start trying to clean it up or address it, we can often resuspend it. They also found that there were a lot of chemistry within the water bodies that were causing the resuspension and causing more problems with different contaminants. And those are contaminant specific. Some contaminants are going to respond more when oxygen is in the water than others when you have a reduced oxygen condition. Here's another problem that we have with coal ash, in addition to spills, is the effluent from the ponds themselves. So when the pond is operating as designed and you're taking coal ash effluent out of the pond, what are you going to do with that material? There's a lot of water that's come into contact with a lot of material in the coal ash, and it's created a wastewater. And this is an analysis that was done in 2012 by Dr. Rule and Dr. Vengosh, looking at the effluents and what was in them. And what it shows here is two things. One is, along this axis are primary pollutants of concern, some of them primarily because of their salts, some of them because they're metals and have toxicity associated with them, some of them just a refresher on what's on the periodic table of the elements. But it boils down to showing that coal ash itself has contained within it a lot of things that we worry about a great deal in every other form of industrial discharge, and yet for coal ash, our regulation of those effluents has primarily been ineffective at the state level. This also shows there's a difference in the composition of those effluents depending on whether you have a fly ash only pond or whether the fly ash is combined with that the flue gas desulfurization or FGD waste stream that I was talking about earlier. So every time you have a situation, with one exception here on manganese, that you have a situation with the FGD, you have higher spikes on the constituents that we're concerned about with FGD waste stream. The conclusion of this study in 2012 is that coal-fired power plants that discharge our coal ash and FGD wastewaters had a significant effect on water quality of receiving waters of North Carolina. We show that even low concentrations of some contaminants, such as arsenic, with concentrations below health benchmarks at the outfall, could become problematic as arsenic is retained in suspended sediments and remobilized with environmental changes in reduced bottom and pore waters. A number of these things react when they get into the environment and become a waste again, but they're waste now entrained in the sediments in the bottoms of our surface waters, causing more problems as we go on. So we have a problem with catastrophic spills. That can probably be, there are engineering challenges to that and regulatory challenges. Containment and getting things away from the water have been one of those things. But that still leaves you with this effluent. What are you going to do with the effluent from this wet process? If you're going to discharge it, you're going to run into some problems. I did want to point out, I wouldn't be a law professor if I didn't point out some law for you all, so that's part of my requirement in order to get credit for giving this presentation. So I just wanted to point out that from very early on in the state of North Carolina, we've recognized that riparian proprietors not only have a right to water flowing by their property to continue to flow and to reasonable use, but they also have a right to have that undiminished in quantity and unimpaired in quality. And one of the things that we get very much caught up in when we talk about the Clean Water Act and many of the other regulatory regimes that are supposed to protect water quality are, what are the appropriate discharges at the outfall? Well, one of the other issues that we also have to think about is, what are the uses that downstream users are entitled to use it, including the public? Can the public go out and catch fish on the Dan River now and be confident that they can feed those to their family? Can the public go out and send their kids to go boating and canoeing, or worse, swimming in these waters and feel confident and comfortable about them doing that? And if not, what are we going to do about it? The law provides some opportunities, and I'm very excited to hear from the next panelists. They're my heroes in this regard. Michelle can attest to this, I actually had on the wall outside my office posted for almost 6 months a single one-pager from a newspaper that I'd cut out. And that one-pager was a single half page of the newspaper. And on it was a full written apology from Duke Energy to people of the United States that was a result of the settlement that we're going to hear about just now. And I considered that to be the greatest achievement of the year, and that's why it was sitting on my door. I had nothing to do with it, but I was very pleased about it, and I'm very pleased to share the podium with these folks who are going to talk to you about how that came to pass, and look forward to questions from you all later. Wanted to make sure to leave plenty of time for them. Thank you.
this one, I believe. This one here.
Thank you to DELPF for inviting me to speak today. As Michelle said, I'm Frank Holleman. I'm a senior attorney at the Southern Environmental Law Center, and today I want to talk to you in brief about the long saga of coal ash in the Southeast and particularly in North Carolina. But I want to lead off, if I can, with the morals of the story, which I hope to come back to at the end. The first moral I would say is and listen to this now carefully, you cannot count on large businesses or government to protect you, with the exception of Lana, Pettus, and the U.S. Department of Justice. With the exception of that one government entity, you cannot count on any of the others to protect you. One. Number two, citizen enforcement and citizen involvement are essential to protecting our environment. Nobody's going to do it for you. And the third point, which I'll come back to the end, is this is a great country. Okay. Now, I want to start out with this point because we're at this great, august institution. There are a lot of complicated environmental and energy-related issues. This is not one of them. This is not a complicated issue. And let me explain. All we are saying is that when you generate electricity from coal, you're left with waste, which is called coal ash. And you have a simple, common sense responsibility to safely dispose of the waste stream. That's it, period. That's not complicated. It almost goes back to the message to young children, you have to clean up after yourself. This is not a complicated notion. And furthermore, there's a very simple, low-tech, 1950s solution that will basically handle the problem, and that is you put it and store it dry in a lined landfill. In other words, you take the same care with this industrial waste that contains toxic substances that we take in disposing of banana peels and Kleenex. No one could do with municipal waste what we've allowed the utilities to do with industrial waste. Now, let me reiterate what you heard before, but make it a little bit more graphic. The utilities, I would never believe this when I started out in this field. The utilities are our richest and most sophisticated, our richest institutions, and are probably the most sophisticated engineering institutions in our economy. How do they store this waste? They take millions of tons of industrial waste that contains substances like lead and arsenic. They deposit them in unlined holes in the ground. Unlined holes in the ground, directly next to drinking water reservoirs, lakes and rivers. Fill those millions of tons of ash, industrial waste, in unlined pits full of water and hold them back only by dikes made of earth that leak. As was pointed out, we are now using 21st century technology to take the pollutants out of our air. We're using 13th century technology to store the waste. I've said this before, and after one event, someone came up to me and said, "You're insulting the people of the 13th century. The Romans would have done a better job at storing this waste than our utilities do," and that is true. Now, I'm going to take you quickly through part of the narrative, and as you will hear when we get to North Carolina, I will just repeat what was said in the movie. It says, if you are not outraged, you are not paying attention. So let me see if I can work the slideshow. That's what we don't want to happen. That's the result of primitively storing this ash, as happened at Kingston, Tennessee. The utilities have known about this problem for decades. This is not a mystery, it's not new, but at least in 2008, nobody had an excuse not to recognize there was a major problem facing the country. Does anybody know what that is? Those are Duke Energy's coal ash lagoons in Charlotte, North Carolina. Now, do you know what that is? Anybody know? That is one of the most important drinking water reservoirs in the United States of America. That is Mountain Island Lake that serves over 800,000 people. Now, Ms. Pettus has enforced the Clean Water Act here. But I think we can go further. This must violate the Patriot Act. Can you imagine allowing anyone to put that beside one of the most important drinking water reservoirs in America? But that's exactly what we've done. And to show you the consequences in the region where we live, there's a set of these lagoons in almost every major river system in our region, which are responsible in our region for more than half of the toxic pollution of our waterways. On the Catawba River near Charlotte, there are 4 sets of these lagoons. All right, so where did we start? Why did we get involved? Well, the EPA was supposed to pass rules after this 2008 spill that would solve the problem. But you may have heard there is something in Washington called gridlock. And the utilities and their lobbyists were very effective at really freezing that process. So when we got to 2011, it was apparent to us that we could not count on national regulations to save us, and it was abundantly clear the state governments were not going to do anything about it. So we said, well, instead of waiting for a new regulation, why don't we just look at these sites, the risks they may or may not pose, and see if we can enforce the law that exists. In little old South Carolina, which is sometimes viewed secondary to North Carolina, South Carolina has an anti-pollution law that citizens can enforce themselves. So we started looking at the South Carolina sites, and to the credit of the state agency, they had determined a number of these sites openly violate South Carolina's anti-pollution laws. It was in writing. We discovered nobody had publicized it, it hadn't been in the press. But nothing had been done to enforce the law. So we just went into court, boom. Said, guess what? You're violating the law, clean it up. First time anybody had done that in our region. We started with the site on the Catawba Wateree River. We filed suit. As you law students will know, we faced the typical standing and jurisdictional motions. We won those motions. We settled the case. SC&G agreed to remove all the ash from its lagoons right above the Congaree National Park in South Carolina. As of today, they've removed 1/3 of the ash, and the arsenic contamination of the groundwater has dropped by 90%. And they're going to remove all the ash to safe dry line storage. To our knowledge, that's the first time anywhere in our region, and maybe it's happened somewhere else in the country, that an enforcement action of an anti-pollution law resulted in a utility excavating a waterfront lagoon and moving it to safe dry line storage. Then we went further in South Carolina. Before I get to this, we went to Santee Cooper. We litigated with them for some year plus. Again, survived motions to dismiss, this time on a different basis, but at that time we had to be in state court because they're a state government entity. And believe it or not, a South Carolina state judge ruled in our favor against Santee Cooper in its second hometown. Santee Cooper settled with us after fighting fiercely for a year or so, agreed to clean up all the ash out of water-filled lagoons near Conway, South Carolina, and at the same time announced it was going to clean up every such site in its system. And so did SCE&G. And to cut to the chase, in South Carolina today, as we stand here today, there have been no criminal prosecutions, there's no current pending litigation, and the utilities either are, have done, are doing, or are committed to clean up every unlined waterfront coal ash storage site in the state. There are 3 major utilities in the Carolinas. Anybody know what the third one is? Duke Energy. Has the same name as this institution. That, again, is the Charlotte. This is where Charlotte gets its water. That's where Duke stores its coal ash. Water flows like that. The head of the Charlotte-Mecklenburg utility said, if this breaks, we don't have plan A, B, C, or D. There's nothing. In other words, we're going to have mass migration, I guess, to Columbia, South Carolina, if that happens down I-77. So we began by sending 60-day notices under the Clean Water Act. Has anybody studied that? So you know what that means? So we're sending 60-day notices saying if the government won't enforce the law, and if the company won't clean up the pollution, we're going to sue you for it. And we had the gall to file one in Charlotte, the hometown of Duke Energy, and Asheville, North Carolina. Well, in South Carolina, you may have heard we succeeded in a cleanup, and I never mentioned the state government. They never got in our way. We come up here and blithely, send out these 60-day notices and think we might have the same experience, but not in North Carolina. What happened was the state agency actually joined forces with Duke Energy to try to frustrate our law enforcement. Now, let me back up for a minute, and we can be cynical. But I don't think we should be cynical about this. In every other context I'm aware of, when a law-abiding citizen reports illegal activity to the law enforcement agency, I expect the law enforcement agency to work with the law-abiding citizens, particularly when they are the victims of the law-breaking. But in this instance, the law enforcement agency, the State Department, what's now called the State Department of Environmental Quality, immediately began meeting with Duke Energy, the lawbreaker, to figure out how to frustrate the citizen law enforcement. I sometimes say Sheriff Taylor never would have done that. I bet y'all are too young to know. Anybody know who Sheriff Taylor is? Andy of Mayberry? Never would have done it that way. It's a disgrace, really. But so what they did was, on the 59th and 60th days, they filed suits to block our enforcement. Now, to this point, the state had done nothing to enforce the law. Duke was telling us they were obeying all laws and there was no risk. And the state was saying, we don't have any problem with it. Now, there is a problem with the strategy they came up with, which is to preempt our litigation and settle it quickly. And can anybody here, as a law school exam question, figure out what is the problem with that strategy? You cannot sue someone for obeying the law. You cannot enforce the law against someone who is obeying the law. So to preempt us, they had to confirm that contrary to what they had been telling the public for years, and at that time, Duke Energy was actually violating the law. And not only were they violating the law, but it was a serious danger to the health, safety, and welfare of the people of the state of North Carolina. And this is filed under oath. In other words, we were right. But and the Charlotte newspaper supported our position, lo and behold. But to deal with us, they proposed a settlement with Duke Energy, which would not have required a cleanup of any of these sites. In fact, the Duke Energy lawyer told us we will never clean them up, never remove that ash, and had a big fine of $99,000. Thousands of North Carolinians said no to that, thank goodness, under the Clean Water Act. Then the state filed suit to preempt every site in the state, all 14 sites. They sued Duke Energy on all 14 sites, confirming they're violating the law on all 14 sites. August 2013, they filed that suit, including the Dan River sites, one of 14. They spent the next 6 months trying to stop us from proceeding with the enforcement. And the state didn't lift one finger to enforce the law, and Duke didn't do one thing to clean up the pollution. And 6 months later, we had the Dan River spill. That was bad news because it highlighted this strategy in the newspaper of how they were dealing with the citizen lawsuit. That caused a public scandal. Rachel Maddow in 60 Minutes showed up, as well as every other press outlet. And our friends at the U.S. Department of Justice showed up. And you know who this is here? Many of you are not old enough to remember this, but that was Duke Energy's mascot, Ready Kilowatt. And so this is Ready Kilowatt facing the music in the Greenville News and was circulated elsewhere around the state and the region. So at that point, Duke agreed to clean up 4 sites in the state, which they said they would never clean up. And subsequently, we were able to negotiate a cleanup at 3 additional sites, which is good news. But let me tell you 2 things that have happened that should be of concern to you. I told you that Duke and we negotiated a cleanup of 3 additional sites and went to court and asked the court to order those cleanups. Your state Department of Environmental Quality opposed the cleanup in court. Let me say that again. Duke Energy, the polluter, and the conservation groups who are enforcing the law agreed a cleanup is required. State agency, supposed to be protecting you, opposed the cleanups. Now, fortunately, the court, you might imagine, didn't go along with them. They went along with us. 1. Number 2, the U.S. Department of Justice, Duke Energy goes into court in May of 2015, and their general counsel, on behalf of Duke Energy's operating companies, pleads guilty 18 times to 9 federal Clean Water Act crimes for coal ash. And they're placed on criminal probation. 17 days later, the governor of North Carolina and the state's chief environmental law enforcement officer host the executives of those companies for a private dinner at the governor's mansion. When the press discovered this, they've refused to comment, other than they do confirm they discussed the environment. Second key point, under this thing called the North Carolina Coal Ash Management Act, which we could discuss, you now have a chance to express your views. In November 30th of 2015, the professional staff of DEQ recommended that virtually every coal ash site in this state be declared high risk so that the ash would have to be excavated and moved to dry line storage. The political leadership of DEQ, 1 month later, reversed those decisions, did not follow them, watered them down. For every site that Duke had not already agreed to clean up, they either rated it low risk, which may not require cleanup, or said they couldn't make up their minds. Fortunately, we now have a public comment period and an opportunity for hearings. There are going to be hearings for every site, so you have a chance to comment. Now, I began by saying, ending without explaining, this is a great country. I should have given you reason to worry about the country to date, I hope. But what's great about it is this. Duke Energy is the largest utility in America, perhaps the world. DEQ is a very powerful, entrenched government bureaucracy. When we go into court, we, a nonprofit legal advocacy group, represent the Catawba Riverkeeper. 3 employees, the Riverkeeper himself is this young guy, nonprofit organization, and we beat them in court. What other country in the world could these little nonprofit groups against the most politically powerful entity in the state with the most money go in on equal footing and prevail? But it will not happen unless you're involved. Thanks.
Frank's a little taller than I am. Good morning, I'm Lana Pettus. I am a senior trial attorney with the Environmental Crimes section of the Department of Justice. And I'm here to give just an overview of the Duke Energy criminal case. Because I'm an attorney with the Department of Justice, I always have to give some disclaimers. The first is, if you were hoping for the deep, dark, inner secrets of the investigation, I'm sorry, I can't tell you any of that. So most of what I'm discussing is limited to the public record, but I hope, because of the familiarity I have with the case, that it will still be informative. The other disclaimer I want to give is, I am here sort of as the face of the investigative and prosecutorial team that worked on this. I am by no means sort of the sole person responsible for the results in this case. There were attorneys from all 3 U.S. Attorney's offices in North Carolina, to include Bonnie Rangarajan in the Raleigh U.S. Attorney's Office, who, if you've not met her, has done decades worth of environmental cases and is a fantastic resource for any of you interested in practicing that kind of law. We had agents from multiple federal and state investigative agencies, and without all of those people, none of this would have been possible. So I'm here to talk about this, but this wasn't my sole effort alone. So touching a little bit on what's already been covered by Professor Longest, this is sort of a depiction of how a coal-fired power plant works and the waste streams in a very simplistic form, which is about as much as I'm able to say about it. But you can see, as the coal ash is burned, the different sort of emissions control devices and how they filter out sort of different layers of the waste. All of those get ciphered into the coal ash pond that you see there on the right-hand side of the screen. To include, you have the FGD, the scrubbers as they're commonly known. In this case, you can see sometimes they're discharged directly to rivers, depending on what facility you're looking at. Most of Duke's actually went also into the coal ash ponds. So this is actually the coal ash pond at the Dan River facility before the spill. To give you a sense of the scale, that is acres big. So it's always kind of a little bit funny when we talk about them being coal ash ponds, because you think, oh, pond, small body of water, ducks, like, not at all. They're enormous. It had a primary pond, which is the grayer, larger pond, and a secondary pond. The idea being that heavier particulates will settle out of the first pond, cleaner water then filters into the secondary pond where there's more settling, and then is discharged into the river. In this particular pond, that primary pond was expanded at some point back in the 60s over top of 2 pre-existing stormwater pipes, which, when I first got the case, and I'm not an engineer by any stretch of the imagination, I thought, that seems really dumb. But such as it was, that's what happened. It turned out that the 36-inch stormwater pipe was made entirely of reinforced concrete. The 48-inch stormwater pipe, which was older, the first segment of it was actually made of corrugated metal. So you have a corrugated metal pipe sitting under a big pond of water with water running through it. The water around it from the coal ash pond tends to be acidic, so you can imagine what would happen to that pipe over time. So, sure enough, you have, the spill. So you can see in the top right-hand corner the pond after the spill and how the ash has sort of caved in to where the pipe breaks. The picture in the center is actually the segment of the stormwater pipe that corroded, sort of buckled in on itself, and shot out the end of the pipe, which you can see there at the bottom right-hand corner, into the river. So the picture in the center is actually them. They've located the stormwater pipe section in the river and are pulling it out. So when you have a spill like this, it hits the news. Obviously, everyone becomes aware of it very quickly. People are pulling together an investigative team, and then you've got to decide, what are you going to do? So the steps in the investigation are kind of first figuring out what happened, on what timeline, who was involved. We're also, though, looking at things like, what are the effects? What is happening as a result of this? So we were looking at, what are the responders from Fish and Wildlife Service and other agencies, state agencies, finding as they're out here responding to the spill? What sort of harms might there be to organisms in the river? What sort of harms might there be to human health? So there's a lot of moving parts going on in the investigation. We also, as we're looking at things, kind of exploring the background of the company, and of course, the North Carolina, it was DENR at the time, now DEQ, enforcement actions came to our attention pretty quickly. And as we're reading through those, we recognize it looks like there are some other problems here as well. And so at that point, the investigation broadens beyond just the spill itself into sort of the broader conduct of the company. So at that point, then we realized that we were looking at 14 facilities in 3 different U.S. Attorney's Office districts in the state of North Carolina. And so part of our job is to sort of divide and conquer a little bit and try to figure out what's going on at each of those facilities to the degree we can tell, while at the same time trying not to hinder or slow up our response to the spill itself. Being a little slow here. The other thing that was a somewhat complicating factor here is when you're dealing with a very large corporation, determining the who's responsible can be a little difficult from a legal perspective. And so what you have with Duke Energy Corporation, and this is actually just a fragment of the corporate structure, but these are the subsidiaries that actually operate coal-fired power plants. We discovered that we were going to be basically dealing with 3. The 2 on the right, Duke Energy Carolinas and Duke Energy Progress, actually sort of own and operate the facilities, the power plants themselves. Duke Energy Business Services is sort of this separate entity that Duke Energy has that sort of provides expert staff to the other entities. And so personnel from that company are involved in helping run and manage the activities at the other 2 entities' facilities, even though they don't actually own them. So that's how we ended up deciding that that corporation would also have liability in this situation. And of course, as the investigation continues, we found that there were additional issues existing at various of the facilities that weren't necessarily enumerated in either the spill, what we knew about the spill, or in the enforcement actions that we had access to. One was bromide discharges. That's actually a function of the FGD scrubbers. So that waste stream has elevated levels of bromides, which themselves are not actually regulated. There aren't limits in terms of how much bromide you can put into a river in North Carolina. But if you have the right conditions in the river and you have a drinking water system intake close enough to where that bromide is coming out, and your drinking water system uses a certain process involving chloride to treat your water for drinking, you can end up with trihalomethanes in your drinking water, for which there are limits because they are potentially carcinogens. So we found that at least 2 or 3 different communities along the Dan River, because Bellows Creek, which is another facility upstream from the Dan River steam station, had installed a scrubber, and these entities didn't, or the wastewater treatment facilities didn't know that these increased bromide levels were going to be coming their direction. They were seeing spikes in these trihalomethanes in their drinking water. So that was something we were looking at in terms of how do you address that? Is it possible to address that through the criminal process? You also had an issue at the Sutton plant, which there's a screen grab actually from Duke Energy's website, where there was evidence that contaminants had entered the groundwater from the coal ash pond there and were migrating towards drinking water wells of a community called Flemington, which is just outside of Wilmington. So we were looking at, can we address that in this process? And then there were just other less substantiated or less sort of well-developed claims of potential groundwater and wetlands contamination. And you can see there in the other photograph what is known as a seep, which is where water is interacting with the coal ash pond, and it sort of resurfaces some distance from the dam wall and emerges as these seeps. And sometimes if they reach groundwater, that can be a Clean Water Act violation. There we go. So as we're looking at this, we have to assess which of these violations or potential violations is an environmental crime. And the focus, or one of the focuses for us in making that determination, is the intent of the person responsible or company. There are lots of different kinds of intent. Willful, so sort of you know something's illegal and you're doing it anyway. Knowing, which is you know what you are doing. You may not know the ins and outs of the law that prohibit you from doing it, but you are still responsible for your actions. Willfully blind, where you sort of kind of know something's wrong and something's probably going on, but you deliberately avoid gaining the knowledge that you should otherwise have to know what is going on. Reckless is sort of similar. And then negligence. So that's a failure to exercise the kind of care that a reasonable person would. And you can be held criminally liable for being negligent. There we go. Now, the difference in these is that first category, those first levels of intent, often are charged as felonies. They're specified as felonies under the environmental statutes that we work with. Negligence is often a misdemeanor, so it's a lower category, I guess, of crime. And the way we sort of differentiate between those is sort of the lengths of the jail sentences that go with them. So in the federal system, a misdemeanor is generally punished by a year or less in jail, and a felony is something more than a year. Obviously, you don't send a corporation to jail, but we still use that differentiation. The Clean Water Act prohibits you from discharging pollutants, which has a special meaning, which is really fairly quite broad under the Clean Water Act. It can be anything from rocks to highly toxic substances into waters of the United States, which also has a special meaning that, if you're interested, we can go into that later. The exception is if you get a permit for particular discharges. But if you get a permit, that means you have to follow all of the terms and conditions of that permit. So there may be limits on what you can discharge, limits on concentrations within your discharges. It can also require you to follow certain practices and procedures at your facility. That actually became an issue in this case. And so if you knowingly violate the provisions of the Clean Water Act, that's a felony. If you negligently violate those provisions, it's a misdemeanor. In this case, we had charges that were based on 5 of the facilities Duke Energy owns and operates in North Carolina. The first was obviously the Dan River. The discharge is fairly obvious, at least from one of the stormwater pipes, which would be the 48-inch that collapsed and caused the spill. At the same time, or shortly after the spill itself, it was discovered that other smaller pipe was also leaking badly and discharging wastewater that contained high levels of arsenic directly into the Dan River. So there was another charge for that pipe. In addition to that, the permits that Duke Energy received for making discharges from these coal ash basins required 2 things relating to the operation. One was that you maintain your equipment and the coal ash ponds in such a way as to minimize the likelihood of a spill or discharge, which didn't happen. And the second was to basically maintain and properly operate your equipment so that it would not fall into disrepair. That was also violated. So we had 1 failure to maintain discharge for each stormwater pipe at the Dan River facility. Cape Fear is another facility owned by Duke Energy. This one was a little bit different in that the failure to maintain was based on the maintenance of the riser pipes within the pond. This is an example of one of those. So the riser pipes are basically how water gets from the pond to the discharge point. The idea is that the water gets high enough in the pond that it overtops the top and then trickles down and gets discharged out the river. And because these are settling ponds, the water at the top of the pond should be cleaner than the water towards the bottom. In this case, the joints, so the riser pipes are basically concrete sections stood end on end. The joints between each section were just leaking. So water was intruding from lower parts of the basin and flowing out to the river, and had been for some time. The structure on the top is a skimmer, so the idea is to keep trash and leaves and things from actually entering the riser pipe. That was not in particularly good repair either, but didn't affect the functioning of the pond in the same way that the leaking joints did. So they were charged with having 2 of these pipes that were essentially in a state of disrepair. Part of the reason that was discovered, however, was there was an overflight because of all of the interest generated from the spill of this facility, and someone captured footage of a truck at the side of this coal ash basin with a hose in the pond and a hose leading to a manhole cover at some distance from the wall, which looked sort of suspicious, like you were just pumping stuff out of the pond. The reason given for that was that they were actually trying to repair these and needed to lower the water of the pond. We didn't charge them for that actual process because it was not clearly a violation based on some interactions with the regulators and that sort of thing, but we did charge them for the failure to maintain the pipes in the first instance. The other 3 facilities, we were able to identify specific seeps from those coal ash basins that were making their way directly to a water of the United States, and so those were discharge violations under the Clean Water Act. So we entered into plea agreements with each of the entities. Oops, don't know what happened there. And so when we look at how to conclude a case, whether it's signing a plea agreement with the defendant or arguing for a sentence after a trial, we're guided by sentencing factors that are set out in the United States Code, Title 18, Section 3553. And these really get at sort of what is the purpose of a sentence? What is the purpose of a criminal prosecution? You want something that reflects the nature and seriousness of the offense. You want to protect the public if there's any continuing risk there. You want to deter other companies or other potential defendants from engaging in the same kind of action. You want to deter this particular defendant from repeating their action. If there are victims, if there's been harm, you want to right that to the extent that you can. Often we think of rehabilitation in the context of individual defendants. Putting them back on the right track, but that can also be true of companies. If they've got operating practices that lend themselves to violations of the law, particularly where you have something that involves negligence like this case, you want to make sure that that isn't allowed to happen again. And you also want to make sure that the sentences are consistent or uniform in terms of similarly situated defendants, if you can. And actually, let me go back for a second. So I don't have any slides on the monetary results of this, which I think is what garnered the most press attention. We ended up with a $68 million criminal fine, which is money that goes to the Treasury. There was a $24 million community service payment with monies going to parts of Virginia that were affected by the Dan River spill, but also the state of North Carolina for environmental projects to improve the river and to kind of compensate for the sort of indirect harms that people suffer from environmental violations. And also a $10 million wetlands mitigation program. The idea being that These facilities are located all along rivers. They've certainly had impacts on the river ecosystems, on the wetlands around those systems, and so that's a more direct way of addressing or sort of compensating for those. The other things we did, though, were, again, sort of these things aimed at changing the behavior of the defendant and preventing a recurrence of this kind of conduct. So we had a nationwide environmental compliance plan. Some of the things that addressed was making sure that Duke was dedicating sufficient organizational funding to environmental compliance. We required them to have and designate compliance officers within each of the organizations so that there was a person responsible for looking out particularly for these issues. They are to have annual environmental audits. There's a reporting hotline so that if people are observing things either within the company or outside the company, that information is getting to the right person within the company. And environmental training for their employees. There's a statewide component that applies just to the entities within the state of North Carolina. One of the highlights there that Frank referenced in his presentation is record keeping of impoundment volumes. One of the things we ran across as well was when the Dan River spill happened, no one knew what the volume was there either. How much was there to go into the river? And so hopefully this will mean that if something like that should occur again, people will be armed with that information in terms of responding to that spill. We also implemented, even though we couldn't have any charges based on bromide, a remediation claims process so that local governments with water treatment systems that may have been affected by these increased bromide discharges could come back to Duke and ask for compensation for any adjustments they have to make in their treatment process as a result of these increased discharges. There's a court-appointed monitor, so a neutral to oversee and make sure that Duke is doing what it's supposed to do under the plea agreements so that doesn't fall entirely to the court and the probation officer or even to us, where we may not have the time and the resources to dedicate to that work. He actually will be making written reports, at least annually, to the court, and all of the material he generates will be available to the public. So that is something you can go look for and see and find. There are a number of other provisions in the plea agreement, again, that don't really sort of fall directly under what people classically think of as criminal penalties, but again, were designed to address some of these other concerns laid out in sentencing goals. So things to make sure that they comply with basin closure provisions mandated by the state, where they are now paying for extending a drinking water line to the community of Flemington so that they're no longer reliant on those drinking water wells. And again, public access to documents so that this stuff is in the light, which hopefully will help hold people accountable.
So thank you to all of our panelists for a really interesting and informative and somewhat horrifying presentation. We're going to open up for questions from the audience. So while you're collecting your thoughts and questions, I wanted to ask a question of the panelists. You know, we've been talking about the coal ash disposal sites for electric utilities, but from my thinking, this is just maybe the tip of the iceberg, that these are certainly the biggest and therefore maybe the biggest sites and therefore the ones with potentially most risk of harm. But there are also other coal ash disposal sites associated with smaller coal-fired electric generating units. Duke University, for example, used to have our own coal-fired power plant, presumably produced coal ash that needed to be disposed of. UNC down the road still operates a coal-fired power plant. There are power plants associated with cement manufacturing, with car manufacturing, with a number of other entities in the United States. And I'm wondering if anybody has an idea of how many coal ash disposal sites there actually are, including some of those smaller sites, and whether those are also falling under some sort of regulatory oversight at this point.
I can say that when, actually, according to what I have seen, this is the iceberg, but there is a tip. And what I mean is, when the EPA did its recent set of regulations, I think EPA determined that in excess of 95% of all the coal ash in the country is generated through burning of coal to generate electricity. And the major utilities are by far the principal generator of those. There are some smaller for-profit companies, one's called Cogentrix, for example, in this general area, who have burned, do or have burned coal. And as you say, there are sites like in Chapel Hill, there's an issue now about a coal ash storage site at the police station. If you know where the police station is on Bowling Creek, there's a coal ash site there. The city owns it. It may have come from UNC. We're not sure. So there are other sites, and occasionally we hear stories of issues about storage elsewhere or discovered unknown sites. You may have read recently there's an elementary school in northern North Carolina where they found coal ash in the playground that had come from Cogentrix. And so they're doing something to address that. Back when people were saying, oh, coal ash just like dirt, just here, take it and use it as fill. So there are other sites, but the huge bulk of the problem, as I understand it, is this. But I don't know if y'all know more.
I would certainly agree that's where the bulk of it is. Certainly in terms of volumes, when you're just talking about the volumes, we're talking orders, several orders of magnitude higher for the electric generating utilities, especially the investment-owned utilities as opposed to the smaller boilers. There are industrial processes that did use coal-fired power, and those would be present and as well. But the one of the biggest issues is that during the time frame that, say, from the 50s onward, there were a lot of uncontrolled experiments that we have allowed to take place on the population. One of them is to put coal ash into old coal mines. That has been termed in many cases beneficial reuse or recycling. But coal mines themselves often have direct connections to groundwater. And so when you fill a coal mine up, and of course you have mine drainage problems associated with chemistry in the mine. So if you grew up in Pennsylvania and you've decided, hey, the solution to my coal ash problem is to solve my coal mine problem by filling it up with coal ash, you've actually made one problem worse. You've created a worse problem. I'm reminded of the Cat in the Hat children's tale where he puts a ring around the bathtub when he takes a bath, and every attempt he makes to clean up the ring he left around the bathtub just spreads the stain that he left more and more. That's kind of what we've seen with this process, and really dry ash handling and completely lined landfills. And I want to be clear, too, lined landfills are also not a perfect solution. Not everyone who constructs a lined landfill is a reputable operator. There are lots of reasons to cut corners, and it's very hard to know after the fact that somebody put in 3 inches of compacted clay instead of 12, or that they didn't weld the liner completely to specs because that would cost them more. There are problems with lined landfills. It's not a completely foolproof technology, but it's far better than a abandoned coal mine or, in these cases, an earthen dam. I mean, these are basically, I reminded myself, I got into, did most of my early litigation as an environmental lawyer against leaking hog lagoons. And imagine my surprise when I was very upset at what we allowed in terms of treatment for swine waste. Imagine my surprise to find that hundreds of millions of gallons of material that is maybe even arguably as dangerous, certainly probably worse than swine waste, is being held in these ponds. And as you say, we could, certainly in terms of the way that we're handling the air pollution controls on these facilities, we could do at least as well with the water pollution controls. So I think that the bulk of it is in these coal ash impoundments at these facilities, and then there are going to be beneficial, what were thought of as beneficial reuse sites, which I think is what the Chapel Hill Police Station was, where people just piled coal ash in a place for a structural fill. Those are the places we're going to have to watch out for and look and monitor time going on, because not every place where that's happened was in any way, shape, or form ever a good idea. One of the beneficial reuse products is in cement, and I don't want to cast, I think the jury's still out on cement, but certainly it's hard to do that when you've mixed together 4 different waste streams. You really are not creating a good stream for recycling, and that's what they've done here, typically.
Questions from the audience? Jeff?
Jeff Hughes with the UNC School of Government Environmental Finance Center. That's my title. Kind of shows I'm pretty interested in the finance side of it. Could you comment about the costs that are going to be incurred to deal with the cleanup? If you do go the line landfill way, I think it's probably about $40 to $50 a ton. My guess is for transportation, if you count, but it could be cheaper. I'm just curious what your feelings are, or who should incur that cost for both the cleanup and then the ongoing management. I personally think that our cost of electricity doesn't take into consideration a lot of externalities. So in some ways, this would be, quote, good news for adding to the cost of electricity that we all use, because this coal ash management cost is not being taken into consideration. So that's just a personal commentary, but could you comment about what's happening now and what you think should be happening with those costs?
Yes, if I could, this is I'll answer it directly, but I do want to put it into context. This whole system really, to me, is phony. And let me explain why. You cannot get a permit just to dump junk in a river. There has to be a reason for it, a rationale. And the rationale, as you have heard, is that these are wastewater treatment facilities. That's how they get a permit, as a wastewater treatment facility. Well, that's really not true. And what I mean is, coal ash does not have water in it. This is a settling pond. It doesn't have water in it. You don't need a settling pond to treat coal ash waste. Why does coal ash have water in it, you might ask? Well, there are really 2 reasons. The first reason is that instead of transporting it 100 yards uphill to a lined landfill, it was either bureaucratically easier or thoughtlessly easier or cheaper to sluice it to a lower point and let gravity take it down with water. So they're not treating this waste. They have added water to waste to transport it. And then they seek a permit to discharge contaminated water that they have created by choosing this means of transportation when another was available. So they have added this cost to the system that need not have been there. I mean, this is their own, and really, and just think of it for a minute. In what other industry do we permit as a wastewater treatment facility an unlined pit in the ground that by definition leaks? I mean, it's a waste transmission facility, not a waste
livestock
treatment
industry.
Right, but even they have to do lining sometimes.
Sometimes.
Right, but remember, the waste, the stuff the pigs excrete has water in it.
Right, true.
The other reason it has water, coal ash doesn't. And the other reason it has water in it, they put it in an unlined pit next to a river, and those things fill up with water, either from the rain or from the groundwater. So the cost here is a self-imposed, knowing expense for a short-term savings. All right, that's number 1. Number 2, Duke, the number you quoted is a number Duke has thrown around and some of their funded academics at UNC Charlotte have used. But I would say in South Carolina, Sandy Cooper's cleaning up all of its waste, 11 million tons. And they have said repeatedly, publicly, they're going to spend $220 to $250 million to do that. Now, I'm using Seneca math. I think that's $20 a ton. And they have proportionately, even though they have only 1/10 Duke's ash, they have twice a heavy a load because they're only 1/20th the size of Duke. They were much more coal dependent than Duke was. South Carolina Electric and Gas is a Fortune 500 company. It's cleaning up every one of its lagoons, and it says it will not affect its rates. So does Santee Cooper. And there are reasons I can explain for that. So Duke has floated out a number to say if we cleaned up every site, it would cost us $10 billion. That's what they have said. Now, that is on its face, a misleading number because $2 billion of that is the cost of going to dry ash handling in the future, which they're required to do anyway. So even their number, you have to reduce by 20% right off the top. So they say it would be $8 billion. This is, and I don't endorse that number because when we were fighting Santee Cooper, they were saying it would cost like a multiple of what it costs now. Now they're doing it and agreed to it. It's costing much less than predicted. So I don't think we have good numbers from Duke. It's still in the political debate. Who will pay those costs? We do not know the answer to that question. That's been debated politically, and it's up in the air. It's up to either the legislature or the North Carolina Utilities Commission. I do think, though, we have to not only consider what it costs, but what are you getting for the investment? There is some value in a public utility not committing crimes. I would think that would be sort of a threshold obligation we would expect of our monopolies, that we give monopolistic power, that they have to invest the money not to commit crimes. One. Number two, there is some value in them otherwise obeying the civil laws. So I think those are we have to take that for granted. That's a basic investment. There is some value to the company in not losing its reputation from criminal convictions and legal exposure. There is value to the company in avoiding the legal and direct financial costs of things like the Dan River spill and all the other problems. And there's value to the greater community in not having groundwater sources for drinking water and other purposes contaminated for years to come. For example, in the Flemington example in Wilmington, Duke has agreed to help pay for water line. But in exchange for that agreement, they required the local water utility to agree that for eternity, it will not make use of groundwater under a 17 square mile area. Well, why did they go? What? That's them, not us. I mean, it's not even us saying that's off limits. That's Duke's own request. So we are buying a much cleaner groundwater system, less polluted rivers, and also reducing the number of contaminants that are in our environment and ultimately make it into our bodies. So we're buying something for that too. So to me, it's a complicated evaluation. That's the data we have now. Duke says it will cost them $3.5 billion, and that was put into the plea agreement to do what they've said they'd do so far. They said it will cost them $8 billion to do more. I consider the $8 billion number just out of the air political polemic. And I've told you what we know about the two South Carolina utilities.
I think that we should be excited about paying more for electricity so that, because I mean, you keep putting it on Duke, and I think that you've obviously showed all the problems that they've done, but I think sometimes we say that, you know, just we'll be ignorant, we don't care, just give us cheap electricity. And I mean, this is a good opportunity for everyone to see that there's hidden costs here, and that you know. So I do think that's exciting a little bit to kind of show. But I don't know if that's 5% more cost or 2%. We're trying to get to that.
Well, and perhaps that cost needs to be then directed in such a way that it goes towards cleanup and restoration and proper storage rather than shareholder profits in the future. Other questions? Yes, in the red.
Is there a way to regulate the disposal of coal ash so it makes sense and is safe, sort of in a blanket
Yes.
way other than suing individuals for
Yes,
cleanup?
absolutely. It's so simple. It's so simple, but they will not do it because of the political power of the utilities, and that is require that all coal ash be stored in a dry state in an appropriately lined landfill away from the waterways, period. You don't need a daggum Coal Ash Management Act to do that.
Are you saying that because of their political power, it can't? I'm just wondering if there's any regulations of industrial waste that in a blanket way could force them to do anything.
Well, listen, they violate a laundry list of laws. I mean, when I first learned about this, it's got to be illegal. I mean, I could show you some pictures and, somebody in the 7th grade would say, gosh, they got to be violating some law. And guess what? The 7th grader would be right. They violate a suite of laws because just inherently you have a wastewater treatment plant that leaks. That's got to be illegal. Well, guess what? It is illegal. And there are all other kinds of, in each location, we have not explored every legal issue because we haven't had to, and because some of them are more complicated and more expensive. But here is the basic problem. The utilities, as I said before, are the richest institutions in each of our states. They spend, and they are heavily political because they are a creation of politics. They're not a private business per se. They are a legally created monopoly. They are among the heaviest spenders in the political arena in terms of contributions, lobbyists, giving to every politician's favorite charity. They hire super wonderful, nice people to work for them, to interact with the politicians, enable people to do it. And so they are the most powerful forces in the state legislatures. Now, guess who appropriates the budgets, the money for the budgets and the jobs of the state regulators? The legislatures. So if you are a career person in one of these agencies and you're conscientious and you're a good person, you might, for example, as they did in South Carolina, send them a letter and say you're violating the law. But are you going to say, and by the way, I'm going to bring enforcement action to force you to clean up this site? That's the problem. And but there are ways to require the cleanup. Now, fortunately, in general, because of the combination of convoluted regulations the EPA's put in place instead of a straightforward, convoluted ones reacting to all these pressures, the cumulative impact is forcing the utilities to abandon these water-filled lagoons. 5 years ago, I was on a panel, and somebody from Georgia Power said, these are state-of-the-art. In fact, the North Carolina Department of the Environment, 2 years ago in a permit application, said that unlined water-filled lagoon was the best available technology for storing coal ash. They said that in black and white. Of course, they all deny that, repudiate that now. But the combination of impacts is forcing them to go away from water-filled lagoons. It's just not forcing them to move all the ash to safe storage.
Well, and your reference to those, best available control technology leads me to wonder, as a follow-up to this question, are there not legal mechanisms under the, as you reminded me, the Federal Water Pollution Control Act, aka the Clean Water Act, and the Modern Clean Air Act that are designed to be technology forcing? Is there not some way in which, for example, we could say, because this better technology exists, this better method of disposal exists, this type of storage in the future is prohibited? So you've been addressing, cleanup of the existing sites, but is there a way to utilize those existing pollution and elimination authorities to force a better method of waste disposal?
Well, I was going to say, I believe it was the EPA actually kind of came out with the new, they call it the Ccr Rule, in December 2014. So the coal combustion residuals rule. It makes them fits and starts that way. So it's way more complicated than I can sit here and summarize, but for certain types of operations that are either currently active or that people might want to open, it does require, I think, lining for anything new. the one sort of problem that it had was it doesn't really have the opportunity or the ability to go back and address those old sites, which may no longer be active, but may still be contributing contaminants to the environment. So that's kind of a gap, I guess, in sort of the regulatory authority on that issue.
All right, thank you. I think we have to wrap up this panel and make space for the next one. So thank you for your attention, and thank you for sharing your expertise with us.